Hi, my name is Jonathan Benator, and I'm a partner here at Lazega Johanson, and I specialize in representing community associations. I'm going to talk to you about how to hold proper meetings, and more importantly, why it is important that you do so. The first thing to understand is that there are generally 4 different types of meetings. You have annual membership meetings, special membership meetings, town hall style meetings, and finally, board meetings. The annual membership meeting occurs, as you can tell from its name, once every year. There is the meeting where the membership typically receives the coming year's budget, elects new board members, hears committee reports, and discusses items of common interest. A special membership meeting is meant to address a specific issue that requires immediate attention. Special membership meetings are normally called by the board on their own accord, but we sometimes see homeowners petition the board to call a special meeting. This petition has to be signed by a requisite number of homeowners and meet other legal requirements. Notably, only the specific issue stated in the meeting notice can be discussed at a special meeting. If any other issues arise at a special meeting, they cannot be discussed or voted on. Now, a town hall style meeting may be called by the board or organized by the membership without the board involvement whatsoever. These town hall style meetings are unofficial gatherings where no official business is going to take place. In my opinion, holding a town hall meeting to discuss controversial issues or to proactively address membership concerns can, in some situations, be very beneficial to a community. It shows the membership that the board wants to hear from them. Finally, you have board meetings. These meetings can be held on a regular basis or called for special purposes, just like membership meetings. These are meetings where the board conducts official community business, like hiring vendors, planning social events, and reviewing the status of construction projects. Some people think that these board meetings must be conducted in the open and that the membership has a statutory right to attend these meetings. But that is simply not the case. There is no law in Georgia that requires nonprofit corporations to have open board meetings. But you do need to check your governing documents. Your bylaws may explicitly require that board meetings be open to the membership, or you may just have a policy and long-standing tradition of conducting board meetings in the open. If that is the case, sensitive topics like a particular member's outstanding delinquency or covenant violation should be discussed by the board at the board meeting, but as part of its executive session. This is to ensure the confidentiality of these matters. Moving into executive session allows the board to ask everyone who is not on the board to leave for a moment while sensitive topics are discussed. Now, in order to call an official meeting, be it a membership meeting or a board meeting, and conduct official business at that meeting, a quorum must be present. A quorum is the minimum number of people that must be present at a meeting to make the proceedings at that meeting valid. It is usually specified in your governing documents or by Georgia law. In general, every unit or lot in the community counts towards quorum, unless your governing documents or Georgia law provides otherwise. For example, a delinquent owner may be excluded from voting and their presence may not count towards quorum. Getting quorum can sometimes be a challenge though. It is one of the biggest problems we see with meetings. One way around this though is through the use of proxies. If you cannot attend a meeting in person, most bylaws give you the authority to appoint someone to attend the meeting and vote on your behalf. You would give that person a proxy form, and that person would be considered your proxy holder. A proxy form may be general, meaning the proxy holder has complete discretion to act on behalf of the absent member, or it may be directed, meaning the absent member gives the proxy holder authority to act only in certain matters or to vote in a certain way at the meeting. For instance, imagine that Joe homeowner cannot attend the annual meeting, but wants to vote for Jane neighbor to be on the board. He can give a proxy form to somebody to vote for Jane on his behalf. If another, possibly more qualified candidate is nominated from the floor at the board meeting, the proxy holder cannot change how he or she will vote. The proxy holder has to follow the instructions on the proxy form. Finally, in addition to everything else that has been discussed, you should check Georgia law and your community's governing documents to determine when meetings are to be held and how people are supposed to be notified of these meetings. There are certain dates and deadlines that should not be missed. Failure to follow proper procedure in this respect could invalidate whatever action is taken at those meetings. The takeaway is that you should not assume that the way you have been doing things is okay just because it has not been challenged in the past. Your community association is a nonprofit corporation and has to be run like one at all times. If you are not sure of the proper procedure for holding meetings or just need help establishing quorum, using proxies, or making sure certain deadlines are not missed, we can help you navigate this process with care.